If you're just joining us, former Minneapolis police officer Derek Chauvin was found guilty today on all counts against him in the death of George Floyd. Those convictions included second and third degree murder and second degree manslaughter. All of the charges combined carry a maximum sentence of up to 75 years in prison. Floyd died on May 25th last year after Chauvin knelt on his neck for more than 9 minutes while arresting him. Joining us right now for some insight into this conviction, legal analyst Wendy Patrick. Wendy, thanks for joining us as always. First, what is your reaction today when you heard the jury came back with its decision on 3 different charges without asking any questions of the judge, all within 10 hours of deliberation?
Andrew, you took most of what I was going to say. That's exactly why I found it as significant as it was. I mean, this jury has heard 3 weeks of testimony. Remember, week 1, we started with trauma, then we moved to training, and then we talked about moving from the emotional to the clinical cause of death. So this juror heard from the bystanders, they heard from training experts, use of force, medical experts, and then they heard from the defense, and then the prosecution briefly again. All of that testimony, Andrew, 10 hours of deliberation. Now, you could make the joke that, well, gosh, they were sequestered, they decided they better get to business. It's more likely they found it more straightforward than we thought. You know, every time you have to guess what's in somebody's mind when they act, as they did on all 3 of these charges, they had options. It always takes a bit of time when the person doesn't testify. They have to look circumstantially. But they did so, Andrew, in record time, which tells us they did not have the types of questions we wondered whether or not they would.
Chauvin now faces a maximum of 75 years. What's a realistic amount of time he will serve behind bars?
Well, remember that the most serious charge, the second-degree murder, carries up to 40 years. But then, of course, there were some aggravants that they're going to be discussed, and the judge is going to rule on those. That's that Blakely waiver we heard about yesterday. But you are correct in, do we have an upward departure from that based on what is significant at sentencing? But here's the thing. They're going to look at his background. They're going to look at whether he's been in trouble before. They're going to look at mitigants. While he didn't testify during his trial, he may choose to humanize himself during the sentencing phase. All that's going to be taken into consideration by the judge. And I hope you'll have me back to talk about the ultimate sentence, because we just don't know the scope and the character and the quality of evidence that's going to be presented by both sides at the sentencing phase.
It's interesting, Wendy, when you look what happened yesterday, his team was asking for a mistrial because of some of the outside voices that had come in, and maybe the jury had heard that. Maybe they saw the writing on the wall and knew they didn't have a good chance today, and obviously that's how it played out. Do you think they made a mistake by not letting him speak for himself and testify in his own defense?
Well, remember, it's the defendant's choice whether he wants to take the stand. Obviously, upon taking advice from his lawyers, they work that out as a team. But one thing that they always have to consider is the value versus the danger. In other words, what would the prosecutor have cross-examined on, and could he have withstood that in front of that jury? So while it is true that the jury would have loved to have him take the stand, take off his mask, face them, humanize himself, there was too much of a risk. That apparently was the consensus.
Tell us what happens next. He's going to be sentenced, I believe, in 8 weeks. He'll be behind bars until then. You'd imagine he will likely appeal. Does he have a reasonable argument for appeal? And how does that process play out? How long does it take?
Andrew, that's the question everybody's asking right now. Is not will he appeal? Yes, he will, but on what grounds? Now, the judge did him a little bit of a favor yesterday and actually put on the record one of the grounds that he thought he saw. But there are others. And, you know, one of the grounds that will likely come up is change of venue. Should this have been something that was moved instead of tried close to ground zero? But Andrew, you could have moved this trial to the moon and you wouldn't have been able to avoid jurors that have seen that 9 minutes and 29 seconds. Then there's the issue of sequestration. How do we know these are appellate issues? Because these are some of the issues the defense raised along the way, but that were shot down. The judge didn't agree. He did agree to sequestration for the deliberations, but not for the trial. So these will be the things that are raised, and we can imagine that they'll work their way through the system like all cases. Will they be successful? That remains to be seen.
One of the really interesting things, Wendy, when you look at this case, you know, this isn't the only high-profile case like this, but this is one that had video. You know, it reminds you of the Rodney King situation, you know, 30 years ago. Why was there a conviction here? Was it the video that really made the difference? You know, others didn't go this way that you may have expected that it would have.
Well, you know, the Rodney King video was horrible. We still remember that. But this video was pretty bad, too. And it was very emotionally traumatic for all of us to watch. That's one thing I think everybody agrees on. It's very different than some cases that come down to a split-second decision. There's more reasonable doubt that could potentially be created the smaller the time frame. But that 9 minutes and 29 seconds, Andrew, it wasn't downplayed by the other witnesses. It was explained. It was enhanced. It was shown again and again, including by the defense, in order to make some of the points they had to make. So I would say that was front and center, and that did remain witness number one, Exhibit A. That was in the forefront of those jurors' mind. As awful as that was and as hard to watch, they had to keep watching it. So yes, that made a big difference.
All right, Wendy Patrick, we always appreciate your insight. We will be looking forward to talking to you going forward as this case in the sentencing phase is a few weeks down the road. Wendy, thank you.